Number A, Commission, Department, and County Advisory Board to manage wildlife rules and responsibilities.
Mr. Chairman, thank you. I'm Brian Stockton, Senior Deputy Attorney General and pinch hitting for Nguyen. So I'll do my best, but I only found out I was going to be here yesterday. So what I thought I'd do is just kind of go through your statutes a little bit and explain the roles of the board and the duties. And if you have any questions, feel free to ask. Although I'm just here as a substitute, I did represent the commission for several years, at least 2 times in the past. And so I'm pretty familiar with your rules, regulations, and laws, although I haven't actually been here for a year or so. So I just thought I'd like to go through your statute. The board's created in 501.1, NRS 501.167, and you're created for a purpose, and that's to well, we'll get to that in the duties part, but then in 171, there's been some questions that I'm aware of. When members of the board are appointed, you're actually by statute appointed to represent a certain interest. And so when you come to this board to represent that interest, you do have a responsibility to that interest. However, in a representative form of government, and the example I always think of is, that our senators in Washington don't always vote the way I wish they would. They vote to the best of their ability, and they vote for what's right, for the country and for whatever else. So when you're here representing a constituency, you have to keep that constituency in mind, but at the same time, you also have a responsibility, an independent responsibility to both the wildlife of the state and the people of the state as public officials. And so, everybody's aware of what the interests that are represented here. You have sportsmen, the general public, conservation interests, ranching, farming, and and hunters. Because for the 5 members have to have held a hunting license. So those are the interests that are represented. All right. So the next section, there's some housekeeping sections, but the important section that I thought I'd go through is your duties as a commission, and that's in NRS 501.181, and that's where I think we need to. I was just sharing with Director Mayer. There's a quote in the guidebook that you guys are issued that says you own the agency, but that's not the case in the state of Nevada. So what we'll do is we'll go through those duties. Number 1 is to establish the broad policies, and then the broad policies are enumerated: protection, propagation, restoration, transplantation, introduction, and management of wildlife in the state. So what the board does is they establish those policies to kind of guide the department in how they do, how they carry out their functions. And I've talked about it in the past, is that Director Mayer, even though he's the secretary of the commission, he has an independent duty and fiduciary duty to lead the department in the way that he thinks is best and to move them forward in that direction. All right, and then number 2 is to guide the department in the administration and enforcement of provisions. So give guidance to the department if you think it's going the wrong way. And generally that's done through regulations, right? Because we've talked about it a number of times that policies that are established by the board, with certain exceptions, don't have the force of law. Because in order to have the force of law, you have to go through the regulatory steps like you've done this morning. And except for one of the areas that's exempted from going through those steps is the season and bag limits, and I was trying to find a specific section where that exemption is, but I couldn't find it. So if somebody actually needs that reference, I could get it to you later. All right, and then so again, you establish policies or areas of interest, which include all the wildlife and different things like cooperation with the other states. And then seasons and bag limits for big game and upland game animals. Then one of the other duties that happens quite a bit is hearings when someone's dissatisfied with something the department has done on an individual basis. And so in that case, you sit and hear the appeals within the limits of your jurisdiction. And so every government agency that's established has a limited amount of authority that's given to it by the legislature. So in other words, I mean, the most vivid illustration is like when someone is convicted of a violation of the wildlife laws, and they go to district court and they tell the district court judge, you know, I'm not guilty or I'm guilty, and then the district court judge makes a decision. Well, because of the jurisdiction of the district court is over that, then when the appeal comes to you, you can't do anything that would change the result in the district court. So in other words, if I violate a wildlife law and I go to district court and the judge finds me guilty, I can't, and I come here and I argue, well, you shouldn't punish me, you shouldn't take away my license because I really wasn't guilty, that judge was wrong. Okay, you don't have authority to second guess what the judge did. So you have to accept whatever happened in the district court as fact. And that's why you have a regulation in Nevada Administrative Code, Section 501.165, which talks about the hearing. And when you have a hearing on an appeal, there's two steps you go through. And this is in 165 sub 2. And it says you present evidence, but that evidence has to be what's in the record, okay, regarding the suspension or revocation. So, in other words, if I'm convicted of a violation, and let's say Chief Bonamici had arrested me, I can't come in and present evidence that Chief Bonamici did something in some other capacity that was really bad, and therefore you should excuse my violation. Okay, it has to be only evidence that's related to the violation. And then the second thing is because the second section of that, Section 2B, says consider only allegations of procedural error committed by the department. Now what that means is that, you know, if I'm convicted in the district court, the regulations provide a certain penalty for that, right? So if I get my 12 demerit points, my license has to be suspended. And so what they're talking, when this regulation talks about procedural errors, that's what it's looking at. Did the department apply the correct provision? Did it assess the correct number of points? And the result is prescribed by statute. So your authority, at least as far as appeals, is fairly limited. And are there any questions about that?
It's come up before, as you know better than most of us, that, okay, you come in and your license is taken away. The judge said so, but we think that maybe the judge didn't know that was happening. We're not sure. This happened a very short period of time ago, shall we say. Mm-hmm. Where is our leeway in saying, well, we should do something with these demerit points? Do we have any say over the demerit points in this case?
I'm not sure I'm not familiar with the specific case you're talking about.
But we'll call it in general.
You do not have the authority to say the district court did the wrong thing, the district judge misunderstood this, and therefore we're going to see the district judge convicts the person, and so there's a conviction as to a specific crime. So you don't have the jurisdiction to go back and say, well, the judge is wrong, he didn't really violate that section.
Now, you never say that, but the penalty when it refers to the department's penalty, nothing to do with the courts, the taking away of their license.
Right.
We don't have any authority over that portion.
Well, only the authority in statute and regulation, which is fairly limited. I mean, you've got, and that's why years ago they went to the demerit point system. And so you've got a regulation that's NRS 501.200, which really is specific and really limits your discretion to go beyond that, because what it does, is that lists out the specific violations and then provides a specific demerit point penalty for that. And then the statute requires you to apply that demerit point penalty as listed in the statute and apply the penalty. So let's say you've got, let's just take the first one, unlawfully shooting at a game mammal or game bird from an aircraft. That's 12 demerit points. And let's say I come in and say, well, yeah, I was shooting them from an aircraft, but it was only a BB gun, and so it's not so bad. If I'm convicted by the district court of shooting from an airplane, then 12 demerit points is the penalty, and you don't have discretion to say, well, since it was only a BB gun, we'll only go down to 6 demerit points. You see what I mean? So what this system has done, that was enacted by the commission, has really limited your discretion. And I think that was prescribed by the legislature when they went to the demerit point system. Because we all have a tendency to feel sorry for people who are suffering from their actions. But
Okay, Commissioner Macbeth.
Brian, let me clarify what happened in this particular appeal. First of all, we were dealing with an individual that was more an accessory. The main violator was clearly the person that clearly needed to be cited, but this particular individual was a kind of an accessory. He was on the back of a four-wheeler. And the judge, in his order, clearly, in my mind, suspended his fine and was giving indications that he was being lenient, but did not either know or understand what the impact of the pleading guilty would have on this individual. And so we were torn between, and to be quite honest, we were ready to just go ahead and, he was going to get, the hammer was going to drop. But in the end, what we asked is that the department go back to the judge to get clarification what he meant, at least on the civil side. Because we didn't want, we felt we were going to have to make a decision that was going to potentially be in conflict with the intent of what the judge did on the criminal side. And so we wanted it to go, in the end, we wanted to go back to the judge to see if that's, what the impact was going to be on the civil side. So that's what happened. I think it's an aberration. I don't think it's something that we normally would see. And so it was a tough one.
yeah, and that's a perfectly valid response where the district court gives an ambiguous, the district court's holding is ambiguous, go ask for clarification, sure. There's never any problem with that. The problem comes when you say the judge didn't know what he was doing by ignoring the conviction. So that's where we get into trouble. The other thing to keep in mind, pardon me, for cabs as well, and I'm not as prepared to talk about cabs, although I can answer questions, is the thing we need to keep paramount in our mind from my perspective, and one of the big reasons I'm here, is the open meeting law. And I think we're pretty good at it these days about following the open meeting law and the new system that allows at least two periods of public comment and those kinds of things. The other thing is that will get boards into trouble and they need to stick to is sticking to the agenda. And so I know we had, because it was a workshop, it was okay, but on the regulation we started talking about other ideas that might be added to the regulation in the future. At a workshop, that's okay, but what happens if we're on an action item generally is you need to stick to the topic that's in there, and that comes from a case, the Board of Regents was meeting and they were discussing a budget for the campus police department, and the discussion veered off into an investigation that had been conducted by the campus police department. And the members of the board felt that it was related to the budget and how they would vote on the budget, but the Supreme Court said that was too far afield. So the standard is that the agenda item has to give fair notice to a reasonable member of the public, which is what is going to be discussed. And so when you go to topics that are beyond the language of the agenda item, then you get into trouble or get into an area where you may be in violation of the open meeting law. And the open meeting law has changed to where can be up to a $500 fine for willful violations of the open meeting law. So, is there anything else?
I think that's it. You might want to talk about the cabs.
The cabs are created to advise the board, and that's their role, and they have a specific interest and they're created in the county, and the Attorney General's office by statute doesn't represent them, so they are supposed to get their representation from the district attorney in the county they're in. They are held to the same standards. They have, the open meeting law applies to cabs, and they have to publish an agenda. They have to stick to the agenda. They are, subject to open meeting law violations. And their job generally, and I don't have the statute right in front of me, is to take input. The general idea is they're the ones that are closest to the people in their county, and so they take the input from the people in the county and bring that back to the commission, and then they give that information to the commission, and I think most commissions in the past have taken that seriously and considered heavily what the cabs bring in. But as far as the duties within their limited scope of jurisdiction, which is the county they're established in, they pretty much have the same responsibilities as this board, to advise. Well, you advise the board. The board sets policy for the department, and then the cabs advise this board on the interests of that county. So is that enough? Or any questions? I don't know if you want to open it up for cab questions. It's
Yeah.
informational items, so.
Okay.
Commissioner Ray?
Hopefully this clarifies a couple of things. My questions are that, one, related to the order of items on the agenda. When we start an agenda and we want to change the order of items on the agenda for some reason, in what cases can we do that and when can't we do that? And how do we go about doing it?
I don't have the reference right in front of me, so I'm going from memory. And what you generally do, the board has a commission policy that you follow the Roberts Rules of Order. So I think at the time you approve the agenda, what you do is somebody makes a motion to move it around. And I think that's under the open meeting law, which is the actual law. I think it was just changed recently, and so I hope I get this right, and if I'll look it up offline, and if it's wrong, I'll make an announcement. But I think the chairman can change the order of items for other reasons, under the open meeting law. But I think under the Roberts Rules of Order, it has to be done at the time you approve the agenda.
My argument that I've made in the past is since we follow Robert's Rules of Order by our policy, how hard do we have to adhere to that? What if some people want to say not follow Robert's Rules of Order?
Well, it's kind of a tough question. I think you should stay as close as you can to it. What's the penalty for not following Robert's Rules of Order? There really isn't one. Policy is not law, as I've said many times, and therefore you should try to follow it as closely as possible, because obviously when you don't follow your own procedures, you tend to get into trouble, because if those procedures somehow infringe upon the due process rights of someone or on some right of the public, then you can get into trouble. But for the most part, I think the chances are fairly insignificant.
One example I would give of that would be if we don't, Robert's Rules of Order is what gives the chairman power over the meeting. Well, if we're not following Robert's Rules of Order about how we change the agenda, then, well, who says he's in charge of the meeting?
Well,
Who says, voting is equal? Who says?
Well, under the open meeting law, you still have, the chairman is still in charge. The chairman still has the responsibility to maintain order and decorum, and to make sure the meeting is conducted fairly. Because, if people are disrupting the meeting, or if things are going, are not following in a fairly, I'm trying to think of the word, but, regimented order, right? If you don't keep the meeting in under control and in order, then the public's business is not getting done the way it should be. So there is an independent duty under the open meeting law, independent duty and authority to keep the meeting under control. So that's why I say it's your policy. You should stick to Robert's Rules of Order. If you do that, you're not going to get in trouble. If you do, for some extraordinary reason, need to divert from that, as long as you do it in an orderly and fair manner, then you're probably not, most of the time going to be okay. There could be trouble, but I'm having a hard time thinking of an instance where it would rise to the level where you would have.
Anytime you need two-thirds majority of the commission to do something, like I'm here, if the majority is five, say five people want to do something, they know they need two-thirds under Robert's Rules. Well, hey, let's just violate Robert's Rules and we'll get our thing moved around. I mean, that's happened.
Yeah, well, if you do that, then you run the risk of a challenge.
And the challenge would consist?
Well, if, let's say a member in the minority didn't like it, he could file I'm not sure. I'm not sure how it would proceed. I mean, it might go under I don't know that would go under the open meeting law. It might go under the open meeting law because if you don't follow your procedures, then you're obviously not conducting the public's business the way it's supposed to be. I can't think of how it'd be challenged. I mean, you could go to district court, but I think if I was representing the commission, I'd probably be able to beat it. But it would depend on the circumstances. But that's why us lawyers, are employed, is because there's so much gray area, and I can't definitively say if you violate Robert's Rules of Order, that action is void ab initio. I can say that if you violate the open meeting law, whatever action you take is void, period. So I'm not sure that answers your question.
So it may or may not violate.
Right.
Depending on...
If it violates the open meeting law, it's void. If it violates Robert's Rules of Order, it's probably voidable, what we call voidable, which means it's valid unless somebody challenges it.
Commissioner Lang.
If you have contentious issues on your agenda, and the room size is such that, let's say, for example, you can handle 20 people in that room, and 40 people show up, and 20 of those people can't get into the room because of occupancy requirements. Is that an issue for the cab?
It could be. I mean, if they can make accommodations somehow so that everybody's able to listen. And I think one time we had speakers set up in the parking lot here, and I think that was within the intent of the open meeting law. If you can't, nobody could.
What if they don't make, I guess my question would be, there was no accommodation and many people, a number of those 20 people left because they couldn't get into the room. I'm just asking that question. Is that an issue for the cab?
Yeah, it might be. It might be. I mean, it could engender an open meeting law complaint, and I think the Attorney General's office would take a close look at it. And again, I can't really advise the cabs on the open meeting law because by statute they're represented by the district attorney. But when this commission has had issues where we didn't think we could get everybody in the room, we've made arrangements to make sure everybody could at least hear the proceedings and have a meaningful chance to participate. So I would say, I mean, if the board turned people away, the cab turned people away, that could be a problem.
Okay, anybody else? Okay.
All right, well, I apologize that was kind of thrown together at the last minute, but if you have any questions, I'll be here.
Go ahead and stay there for a minute because
All
we're
right.
not done with this discussion.
Could I,
Make yourself comfortable.
would you like me to finish up with what I was going to point out in the guidebook?
Yeah, let's let Director Mayor go, and then I'm going
Yeah,
to
and I'll take
go
this.
into another realm of this here.
Just a couple minutes. There's a commission guidebook that we've sent all the commissioners when they first became appointed. If you want to go to the website, it's downloadable from the website as well. If you wanted you can't find your copy and wanted to refresh your memory, there's a bunch of, this was written by the MAT team, which is supported by the Association of Fish and Wildlife Agencies. And so there's a lot of stuff in here from commissions around the nation. And Mr. Stockton mentioned one of the statements about some states the director works for the commission, some states for the governor, or some other permutations. But I would point you to page 3.1, and I'll just read the role of the commission in it. I think it does a good job of elucidating what your responsibilities are, but it really boils down to 5 or 6 things. First of all, your role as a commissioner is to articulate desired outcomes through policy and focused on policy, to act as a trustee for the wildlife resource right along with the department, to ensure the public participation in the decision-making process, so that above all, you always got to be thinking about making sure that all the public is involved in the decision-making process, and we go extra lengths to do that, and I'm really proud to be associated with a commission that has historically done that, at least while I've been here, and provide opportunities for all citizens to use, enjoy, and learn about the resource. That needs to be a role, and collaborate, of course, with the director on direction of the department, issues that you see that are currently happening or may happen, and I think we've done a good job there. And finally, the commission needs to focus its efforts on what adds the greatest value. And I think that's something that you need to think about as well. And there's another section here, and I won't go over it just for time's sakes, but about the do's and the don'ts. And I think there's a good list of common sense kinds of things that would help guide, and that's on page 4.1 that talks about your understanding your trustee responsibility, and the volume of information that we send you. We're living it day in and day out, but I can imagine what it means to get a box load of stuff to be on top of it, and I think Karen will find that it's very complex. Everyone's connected. You take one thing out, and it has a ripple effect on other things. And so, with that, I guess I'd answer a question or two. Bill?
Mr. Director, who makes the determination of the scope of our duties and what we do to determine the broad perspective? I mean, sometimes I feel as a new commissioner, and coming where I ran in a large organization, it seems like we almost over-micromanage here from this commission in some sense, because we get into some very fine detail that, in my opinion, if you don't have a background in science or biology or range management and stuff, I'm not sure that necessarily we're always qualified. I'm more into doing like the common sense, big picture stuff from a member of the public or the users out there. Who makes that determination? Is there an argument about it? And if there is an argument about it, who settles that?
Well, there is no argument about it. Your duties are set by statute, and that's the statute I went through that talks about establishing the broad policies for the department.
But broad is a subjective word to me.
Indeed it is. And how broad you want to go is up to you. It's up to you as a commission, obviously. The level of detail has to be enough, though, that so you can satisfy your duty. Remember, I talked about your duties to the wildlife of the state and also to the people of the state. And so the detail has to be enough that you're executing those duties. If you're at too high a level, then you're really not, providing that oversight, not oversight, but it's a form of oversight through setting policy. In other words, at some point it may get down to too much detail. And we've had that happen on occasion when I represented the commission, where we had to say, okay, this is beyond establishing broad policy, right? You have to bring it up a level.
So you, as the Deputy Attorney General, would make that call on a case-by-case basis on that argument?
Not make the call. I don't have authority to tell you what to do, but I will advise you and suggest strongly that you stick to your statutory authority.
It really is a custom and culture kind of a thing, and every commission, I talked to all the directors around the nation, have the same kinds of issues, and I guess my story would be that the commission policy is for us to plant rainbow trout or some subspecies, in the waters of the state for fishermen. It's the director's responsibility and the department's responsibility to figure out which waters, what species, what time, all those technical kinds of things. So that's really a clear, but when it starts to happen, depending on who's on the commission, that those lines start to gray. And the custom and culture under some regimes is they want to dictate what time and what water and how many and what species and whatnot. So that therein lies the kind of somewhat of a train wreck, but I think the job of the director is to take that input. I'd rather have the input and then work with the commission to try to find that balance, if you will. And as everyone knows, I'll tell you that I think we're now over into the science, the operational aspects of it. The other thing I've noticed over my career is that it's harder to be a policy guy than an operationals guy. It's much more fun to get a helicopter. And it's really hard to stay just in the policy, especially as you gain a lot of experience and see how things go. So we'll just continue to kind of be like two snakes trying to figure out and go the right direction. So.
Answer my question.
Anything else? Okay, the reason this agenda item is an agenda item is we've had a couple of tough votes that the commission has taken and have been in opposition with county advisory board votes taken at county advisory boards. Because of that, we've been challenged multiple times in open letters that have been circulated around, and I had multiple commissioners tell me they were going to say something during member items. And when I have too many commissioners say they're going to say something during member items on the same topic, it sounds like an agenda item to me. And then there's no time for comments from other people. I saw a train wreck coming with too many members make member items on the same topic. So that's why it became an agenda item. I, as a commissioner and the chairman of the commission, believe in the county advisory board process. I believe in listening to the county advisory boards and taking their input and putting that input into my decisions. I think the county advisory board chairman and members that have been in this room through a couple of those tough decisions have seen that we do take their input, but there was other input offered at that time. And it's kind of a disadvantage to the county advisory boards to see everything that went on. They make their decision before they get to see the whole picture when it comes here. So the decision's been made, say with Tommy and Humboldt County, to steer one way, and then you get in front of this body and more arguments come up, different viewpoints come up, and a different outcome comes. That doesn't mean we disagreed with Humboldt County. That means we saw more of a picture than was given to Humboldt County at the time. And I believe that has happened on a couple of situations. If you look at the voting, we've been challenged that we've gone directly against the county advisory boards, and I don't want to ever be seen as that. I want the county advisory boards to recognize that we do listen, that we do care, but sometimes there's stuff that comes up and is presented to us that you guys didn't get to see. I don't like it being that way. I wish you guys could review our meetings and go back and say, we voted this way last time on this topic. This is what happened at the commission meeting. We support that or don't support that, but we never go backwards. We don't look backwards. We only look forward. And I just want to assure the county advisory boards, we do listen to you. We're not trying to avoid you. But we as 9 members up here have some tough decisions to make sometimes, and we are seeing a more complete picture than sometimes you are offered through just the general stuff you get through the mail from the Department of Wildlife. Sometimes the items are much broader and take much more consideration than you had at your meetings. I wish the process could be different so you had the information to make a different, maybe not a different decision, but consider all the things we have to consider as a board. but that process doesn't work. So I don't know if any other commissioners have anything to say on top of that, but we've been challenged on that, and I want to assure the county advisory boards that's not our intent to go against you. It's just we're looking at maybe a little bit different picture than you are at the time you vote.
And
Commissioner Young.
To go along with that, Mr. Chairman, in my brief time here, I echo your comments. And one of the things I'm finding, and I certainly would take guidance from any of the county advisory boards, is coming from Clark County, we got 2 million people down there. I was born in Lyon County. We probably had much less opinions and diversity and differences out there. And get into Clark County, and as many of you know, I was the sheriff there for a number of years. There's a whole lot of different people with a whole lot of different ideas, and sometimes you don't get all that information in some of the rural counties that we face in Clark County. It's the same thing in fighting crime. We got a lot different stuff that occur there that just because of the size of the population and the number of people and the people that have come from different parts of the world that have settled in Clark County that bring a whole lot of different perspective. And I think that it's our job to listen to our CAB, but we also, as a representative of the entire state and sportsmen and the categories I was pitted for, and Karen's and the general public, and Mike, I think you're a sportsman. We're pretty of just, two of the three of us are representing sportsmen, but there are a lot of other different ideas out there, and I think it's our duty to keep those and take their opinions and listen to them. Listen to them professionally. And I got a lot of heat a couple times already. People have said, hey, Bill, why are you even asking those questions or entertaining some of those ideas or listening to other people? And I said, well, I learned that from being sheriff, because I wasn't just the sheriff for a certain group of people. I was the sheriff for everybody in the county, and that's the way I will operate. So I just to lay that on the table, my perspective.
Commissioner Drew?
Just a couple items on this. Per our duties as defined, I think it lays out pretty clearly what we need to consider, and Mr. Stockton, you can correct me if I'm wrong, but my understanding is that we need to consider the biology provided by the department, the input from the county advisory boards, and then the input and participation of the public. Those are kind of the three main criteria we need to consider in any one of these decisions that we make. I think the department tends to do a very good job of keeping us informed on the biology and the management aspects of those things. I think the CABs do a very good job of coming and providing their input. And I think we've had more public participation since I've been on the board than before I was on the board, which in my opinion is a good thing. But I guess my point in that are those are kind of the three main criteria I look at. So as a CAB representative or a member of the public, what's helpful to me is the better you can articulate your point here, the more informed decision I can make. So facts, if you have, I feel or I have an opinion on this, that's fine, but substantiate that with any kind of fact that you have. This is just kind of the things I use to go off of. I know we've had a couple of occasions where folks have attended a CAB meeting and kind of thought, well, I voiced my opinion, I'll let my CAB representative take that up to the commission. I can tell you that as a CAB member, it is very hard to articulate the opinion of 90 different people in 3 minutes. So I guess my point is, if you're a public and you choose the CAB to articulate your point through, follow that up with at least an email or a phone call correspondence to us. Because for that CAB individual, it's very hard to convey the opinion of that many people to us in a short time frame. So just some thoughts that I think would help me make decisions and open the line of communications a little more both ways.
I think you could add to that list, though, especially for the farming and ranching representatives, they have to bring that perspective to the table as well.
Sure.
Anything else?
Anybody else have anything? I would have to say that I want to encourage the CAB's continued participation. It doesn't mean I'm always going to agree with you, and you're always going to agree with me. But the challenges we've faced with the two very contentious votes that we took we're being challenged by outside groups. We're not being challenged by the CAB members themselves as much as outside groups about our vote against the CABs. So if the CABs have anything to say, you know, I've been told I don't listen to the CABs, and I don't want to ever get that reputation I ignore CABs, because that's not my intent. But I'd like to hear it. If we're doing something wrong, I don't want to just hear it from different organizations. I'd like to hear it from the CAB members themselves, and I'm not. I don't know if anybody else is. I heard from 1 or 2 CABs, but as a majority of the CABs, I have pretty regular conversation with all of those chairmen or members of those boards, and I'm not getting the pushback I am from the general public. So I don't know if anybody else has anything to say
You know,
on
as,
that line.
as the council, really, to stay in the open meeting law, we need to stay just talking, not, once you start debating about whether that's true or not, then you're straying from the agenda item.
Okay. No problem.
Okay?
Okay. Anybody else have anything?
Okay, thank you.
Bob?
Are you taking public comment on this or not?
As council, can you take public
It's not
comment?
an action item, so I don't think you have to, but you're never wrong if you want to.
I'd like to. Bob?
For the record, Bob, speaking for myself, I hope I didn't just hear that the sportsman's representative is taking the public's at an equal weight. We certainly know the ranching and farming would not vote against all of the farmers in the state. Some of the reasons that we don't have 500 people here is because they go to their cab and they get that information and they hear it and they get a second and they get a motion and they bring everything anybody wanted to say from Clark County. They don't have to come up here. Okay, so as a sportsman's representative, that needs to be more weight than just as a ranching or ag would do. That carries more weight because it's not just a straight one for one, I heard this here. For a conservation person, okay, who was the first conservationist? Most people say Teddy Roosevelt, who was a hunter and saw a problem and addressed that. And so if you're actively improving habitat or managing wildlife or purchasing land for wildlife set aside, that's a conservationist. As far as general public, welcome. Last year we had 2,900 and something people apply for a bear tag. I don't remember the exact number, but those are yes votes. They paid money to try and get a tag. And there was about, when we had the no bear thing come up here, there was about 112 emails that came in. 12 of them were from the same person. We also had them from Germany and California and stuff. But basically, for these folks to say that they represent the general public as bear hunters, they're really not. And these folks over here don't really represent the general public either. They've got their own agenda. So the general public person is either the person across the street or a person in Walmart in Vegas. What are their feelings on the bear hunt? I didn't know we had bear hunt. I need this, I need that, I need this. Those are the folks that need to be represented too. So, thank you.
Thank you. Dr. Nguyen.
Mr. Chairman, I think two things you could hit that I think important to have the tell you. One is serial communications. I think that's important, especially for the new commissioners, between the commissioners and the cabs. And the open meeting law has that pertains to. And then also reclusing yourself from, if you have a special interest or something like that. What is the open meeting law, how it relates to members that have a special interest? Those are two things I think would be important for the Deputy Attorney General to tell, especially for the new members. Thank you.
Thank you. Dr. Moldy.
Mr. Chairman, down thanks for a very enlightening discussion. I think it's worth doing periodically. my concern is basically with the general public. You know, this room is not large enough to hold 2.7 million people. So obviously, we're not intending for the general public or everybody in the state to show up at these meetings. And I think it's reasonable to expect that the general public thinks that a state agency with the name Department of Wildlife is going to somehow keep in mind its interests, whatever they may be, and even though they don't show up to speak about it necessarily. But I think they expect something a little bit broader than just what the law defines in NRS as to what each of you represents. And that's why I appreciated Mr. Stockman's comment that while you represent specific constituencies by law and NRS, that you may want to remember that you have a little broader responsibility. I hope I'm not taking your words out of context, but I like that comment, and I fully agree with it, and I wanted to endorse it. Thank you.
Come on up.
Hello, I'm Tom Smith. I'm representing myself. I came here to mention the responsibilities and how I feel. There have been comments made right in this very moment. You have to make hard decisions. Sometimes they go against the will of the sportsman. But that as leaders, you have that responsibility. This is what is said from the highest office in our country to the lowest bureaucrat. We do what we think is right because we are the leaders. You are not our leaders. You should be our followers and our representatives. Politicians get our votes by promising to represent us by asking for our opinions, and then once elected, many of them no longer follow directions or even ask our opinions any longer, but are somehow magically transformed into leaders that know what we want and what is best for us. They no longer represent us. They dictate to us. This is from the highest office in the land. They dictate to us. When every cabinet state with input from sportsmen makes a recommendation to this board and then is unilaterally ignored, as has happened under Commissioner Lent and under Commissioner McBeath, something is seriously flawed. Again, you are not our leaders, but should be our representatives, and you cannot be either if you don't represent us fairly. There are some here who represent agriculture, ranching, and farming. They would be remiss in voting against their interests. I would expect them to reach their decisions based on science and facts on what's best for the people they're representing. I feel the same should be true of the sportsmen's reps. Management should be science-based, not politically motivated. I don't feel that anyone can honestly say they represent sportsmen and then ignore the unanimous input from the county advisory boards. Thank you.
Come on up.
Karen Taylor, Washoe County resident. I just wanted to thank the governor for having some diversity on the Wildlife Commission now, and just a reminder that most Nevadans are not hunters, and therefore this movement towards representing more Nevadans is, in my opinion, a good thing. I did want to say to Commissioner Lane, I understand that you're going to have to make some pretty tough decisions, and decisions that might not reflect those of us who are for the protection of wildlife. And I just want to let you know that I respect that and that you have a difficult job ahead of you, and thank you for being here.
Anybody else?